How are y'all? All right. Good afternoon. We'll wait. I think we got one more press camera. If I get all my notes. All right. Y'all good? Okay. All right. Well, again, I want to thank the citizens of this state for allowing me to serve as their governor. Over the past 6 months, we have had uh, made a lot of progress on the promises that we made last year when we were campaigning. We have worked on crime and public safety. We have worked on educational reform, which we're going to sign some great bills tomorrow. And we've worked on the economy, making Louisiana open for business in either the number of bills that we signed and the restructuring that we did with LED. However, as we know, much work remains. Today, we're here to talk about Louisiana's insurance crisis. Now, I think it's important for those that are watching and the citizens of the state to understand that when you talk about an insurance crisis, it really fits in three buckets. So we know that we have a crisis with property insurance, and then we have a crisis on auto and a crisis in healthcare insurance as well. But today, I want to talk about the work and accomplishments that we've made when it comes to Louisiana's property insurance. And then we'll talk about the work and accomplishments that we made in auto insurance. So, in the property side, like many of those out there, you're faced with high premiums. And I know firsthand the challenges that high premiums in the property insurance industry creates. As the Attorney General, I worked on various actions to mitigate the issues in both the property and auto. We worked to combat frivolous suits. We sued FEMA on the flood insurance program. But there seems to be a continual ongoing political conflict between the trial bar, the defense bar, and the insurance companies. And this conflict does nothing more than hurt the citizens that are out there rather than working collectively to try to ensure that our civil law is fair and transparent and that people in this state have access to courts and then have access to the insurance markets. The consistent conflict does nothing to remedy those things. You know, Hurricanes Katrina and Rita exposed the insurance company to major deficits. Those deficits hurt those insurance companies, but there were also deficiencies. And the deficiencies led to legislative reforms. That was back during Katrina and Rita. The establishment of Citizens Insurance as an insurer of last resort was a product of those two devastating hurricanes. Recently, Hurricanes Laura, Delta, Zeta, and Ida further devastated our state, causing again significant property losses, but also insurance delays, and forced many of our residents to seek legal help. Property insurance premiums and deductibles have soared, causing many of our citizens coverage that's unaffordable. And as governor, I have consistently said that I am committed to finding a balanced solution that supports both the industry but protects citizens' rights. Commissioner of Insurance Tim Temple had recommended changes to the property and auto insurance laws, emphasizing market demands. We recently signed several bills into law aimed at providing relief to homeowners. Today, I signed several bills aimed at reforming the auto insurance market for both commercial and the consumer sectors. But for decades, our citizens have been told that tort reform is the only solution to high insurance rates. Now, I want to just give you a little bit of history. Over the last, since 1994, this state and the legislature have passed 250 pro-insurance industry bills. So again, since 1974, 250 pro-insurance bills have been passed, all with the promise of reducing rates. Prominent voices in tort reform have even been stated that restricting litigation does not necessarily lower insurance rates. So how can all of the pro-tort reform measures that they tell us we have to pass, with the promise, with them in this building, promising them and us that they're going to lower auto insurance rates, and then those same prominent voices go out on a national stage and say things like, we wouldn't tell anyone or anyone else that the reason to pass tort reform would be to reduce insurance rates. That came from Sherman Joyce at the American Tort Reform Association. Or how about where the American Insurance Association issued a press release that said that the insurance industry has never promised that tort reform would achieve specific savings. These are all their quotes. Or how about Dennis Kelly from the American Insurance Association, in an interview with the Chicago Tribune, said, we have not promised price reductions with tort reform. Now, I want to make this clear. I do believe that we should always strive to fix defects in our civil law, which means I support tort reform, because that's where we've identified defects in the civil law, and we ask the legislature to cure them, just like we address defects in our criminal justice system and in criminal law. And so I do believe, though, that when we address defects in our civil law, it is part and parcel towards creating a healthy, competitive market. But let me give you an example of what I talked about earlier, in that promises that were made in this Capitol don't seem to be reflective in lowering premiums for the citizens of this state. In 2020, the Louisiana legislature passed the Louisiana Civil Justice Reform Acts, which included a major revision to the collateral source rule, reducing the amount paid by an injured party who has health insurance by 60%. We reduced the right to a trial by jury from $50,000 to $10,000. That's an 80% reduction. We eliminated Louisiana's evidentiary bar for seatbelt usage in civil actions, which allowed the introduction of those involved in an accident who were not wearing their seatbelts to be admissible when including comparative fault, understanding that if you get in an accident and you were not wearing your seatbelt, then the defense could use that to offset the injuries that you received, because they say if you had been wearing your seatbelt, the injuries would not have been so severe. That was something the insurance industry said would help lower rates. We prohibited disclosing to the jury the identity of the insurers by name. Again, something that the insurance industry said they needed. And the legislature passed prohibiting the disclosure of the involvement of insurance to the jury with limited exception. All things that we were told as citizens of this state that if the legislature passed, we're going to reduce rates. At the time, we were told by both the insurance commissioner and the head of lobby that these reforms would lower rates. However, rates have only continued to go up. Through my experience and research, I have found that other states with lower rates, like the state of Maine, have significantly longer prescriptive periods, which means the time under which you can take litigation or file the lawsuit is longer. But interesting enough, the state of Maine also has a very liberative collateral source doctrine, yet it has the lowest auto insurance rates in the country. And so it made me wonder whether or not Louisiana's 1-year liberative prescription was sufficient, or whether or not we needed to adjust it. What I found was that when you give an insurance company more time to look at a potential lawsuit, it gives them the ability to collect the evidence necessary to determine whether or not the suit is frivolous or not. And what we do know is that if you lengthen the prescriptive period, you're going to lower the number of lawsuits. And the insurance industry has told us time and time again that one of the problems in Louisiana is the total number of lawsuits that are filed in this state annually. One of the bills that we're going to sign into law extends that prescriptive period. That bill will absolutely reduce the total number of tort suits in this state. As such, that should be something that the insurance industry should support. But yet, when we offered it, both the insurance industry and the trial bar didn't like it. So I said, that's a good thing right then and there. That's something that we need. Because when I looked around the country, every other state, except for two, including Louisiana, had a greater liberative prescription. So by passing that bill, signing it into law, Louisiana is now joins the vast majority, we're now the 49th state to have a longer liberative prescription. But again, as I said, we should always strive to fix the defects in our civil law, just like we adjust the defects in our criminal law. And so doing some of these measures is one of the ways that we can help to adjust our civil law. But let me repeat this. It only works if the insurance industry begins taking cases to court. They complain about the jury trial threshold, which we lowered, but yet the number of cases that they're taking to court continues to fall. In fact, I believe last year, or in 23, in 23, we only had like 180 jury trials in the entire state. And that also includes trials by jury in other civil matters. Does not include the criminal side, or 120. It's 120. I think it's 120. It also helps. The prescriptive period also helps to aid us to see who is fraudulently abusing the process and the system. Thus, it should give the Commissioner of Insurance an opportunity to crack down on fraud and those that are abusing the court system, something we really haven't seen the insurance department aggressively pursue. Other bills that we've signed include House Bill 337 by Jack McFarland, which now completely eliminates Louisiana's direct action statute and again places Louisiana in line with 47 other states. Senate Bill 323 by Senator Kirk Talbot adjust the deadlines for insurers, and to initiate and make offers for loss of adjustments with a new penalty cap for noncompliance. Senate Bill 499 by Senator Mike Reese exempts commercial automobile insurance from the uninsured motorist requirement. House Bill 88 by Representative Michael Mellerin changes the venue provisions for foreign insurers. House Bill 784 by Rodney Shamahorn creates immunities over owners of livestock. House Bill 785 by Rodney Shamahorn creates immunities for the national trucking companies in connection with a requirement to install optional safety devices. Senate Bill 10 by Thomas Presley repeals the single business enterprise, recognizing separate legal personalities among affiliated corporations and other business entities. Senate Bill 355 by Senator Jeremy Stein regulates litigation funding by third parties. And House Bill 2, which we signed during the criminal crime session, creates immunity from civil liability under certain circumstances for law enforcement. Again, these are all bills that we have signed based upon feedback and information from the insurance companies. I also offered during this past session to sign into law legislation that would reduce the jury threshold to 0. I also offered to sign a bill to reverse the Housley presumption, which many of you may not have ever heard of, but I do believe that reversing the Housley presumption, which is bad case law, will likely decrease the number of frivolous suits. So that takes us to why we're here today. It takes us to House Bill 423, which has been a hot topic of discussion amongst the media and many radio pundits. What is absolutely entertaining is as I read the articles and listen to the radio and field texts from some of my dear friends, not one of those critics and not one of my friends who texted me can even explain to you or me what the collateral source doctrine is. In fact, those watching are probably scratching their head. But they've heard that if we eliminate it, it is going to be the panacea to our high insurance premiums. But the problem is that those that are saying that are just parroting what the talking heads in the insurance industry and the defense lawyers in the legislature are saying. Again, it's as if the insurance company tells you that you're going to die, we should just lay down and die. Anything that they say, we should just take as truth. But yet, again, what they're saying outside of this building is different than what they're saying inside of it. So to the viewers that are watching and the citizens of this state, let me tell you what the collateral source doctrine in Louisiana is. And how does our current collateral source doctrine compare with other states? Let's look. Our current collateral source doctrine puts us in line with a vast majority of states. That's what you see in the green. In the blue are those states that have a more liberative collateral source doctrine. In other words, Louisiana would have been blue had we not made the changes to the collateral source doctrine in 2020. In red are those states with a more restrictive collateral source doctrine. But what's interesting is that the state with the lowest insurance premium is in blue, and two of the states in the top 10 highest are in red. The collateral source doctrine is a principle in tort law that ensures the insured victims receive full compensation for their damages, regardless of any third-party payments, like those people who have health insurance. The doctrine aims to protect the working class by preventing liable parties from reducing their payment responsibilities based on the injured insurance coverage. What's amazing to me is that if you're going to protect the working class, the collateral source doctrine is the only portion of tort law that protects the working class. It protects people who go out and who work and who obtain health insurance. And it says that if you go and you obtain health insurance and you get injured at no fault of your own, because you have insurance and you go and you get injured and you have to go to the hospital and your insurance is going to cover a portion of it, that if you didn't have insurance, the hospital would have charged you, let's say, $10,000 for a broken arm. But your insurance has negotiated a rate of $5,000. That's a credit that because you have health insurance, you've got. But that's what this bill takes away from you. In 2020, they took 60% of that credit away from you. And they said, you don't get credit by being responsible. But if you don't have health insurance and you don't work, you get the full $10,000. Now tell me how that's fair. The doctrine's core values are fairness and justice, ensuring that responsible individuals like the working class who maintain health insurance are not penalized. And efforts to modify this doctrine can undermine its protections if we don't do it carefully, affecting consumers, again, who responsibly maintain insurance and potentially widening the disparity between those with and without such coverage. So let's put a face on it. Let's put a face so that everyone understands what all of the critics out there are talking about. Let's put the collateral source doctrine into action, into real life. Because here with me today from Shreveport are Kelly and Randy Anthony, who testified in opposition to House Bill 423. They represent, come on up. They represent a real life story of the effects of the collateral source doctrine on the working citizens of this state. We cannot lose sight of the effect that this doctrine has on the day-to-day lives of the people that we represent, especially when the majority of those criticizing the issue don't even know how it works. In 2012, Kelly and her two young daughters were severely injured when the brakes failed on an 18-wheeler and crushed their minivan. Every moment of their lives since that crash has been altered. For 15 years before that crash, Kelly worked as a public school teacher. Each month, she paid health insurance premiums for herself and her family. In exchange for those payments, she was given a discount by those healthcare providers. Under the collateral source rule, Kelly and her family should receive the benefits of that discount. Under the bill that I'm vetoing, the insurance company that represents the trucking company that almost killed her and her family would receive the benefit for that discount. Now tell me how that is fair. House Bill 423 would cost families like the Anthonys tens of thousands of dollars that they need for medical care and education. People like the Anthonys who do the responsible thing and purchase health insurance should not be penalized. I would like to give them an opportunity to explain their story.
Hi. On behalf of my husband, Randy, and our daughters, I would like to thank Governor Landry for vetoing House Bill 423 today. Governor Landry's veto illustrates his commitment to protecting the rights of the hardworking citizens of Louisiana. On February 4th, 2012, my daughters and I were severely injured when an 18-wheeler driver jumped out of his truck and let the truck go unmanned through an intersection because his brakes failed. After filing a lawsuit, we discovered that this truck had experienced 6 other brake failures in the 45 days before the crash. Despite being told of each brake failure, the trucking company continued to put the truck on the road without performing any maintenance on the truck. As a result of the crash, I sustained over 25 broken bones, including multiple spinal fractures, skull fractures, and a broken arm. My daughters, who were 6 and 7 years old, both sustained brain injuries in the crash. One of my daughters suffered 7 skull fractures. For 15 years before the crash, I worked as a public school teacher. Each month, I paid my health insurance premiums for myself and my family. In exchange for those payments, I received health insurance, and I also received the benefit that if I was treated by certain healthcare providers, I would receive the treatment at a discounted rate. Under the collateral source rule, I received the benefit of the discount I paid for. Without the collateral source rule, the trucking company that almost killed me and my daughters would receive the benefit of the discount that I spent 15 years paying for. That simply is not fair. If House Bill 423 had been the law when our crash occurred, we would have recovered tens of thousands of dollars less for our injuries. That money has been critical for our family. Before the crash, our girls were gifted students. Their brain injuries severely impacted their cognitive function. We had to pay to put the girls into private schools and for them to have specialized tutoring because of their injuries. They have required medical care for their injuries, including counseling. I am no longer able to work because of my injuries. I'll need medical treatment for my injuries for the rest of my life. Every dollar we recovered has been essential to our family's future. Governor Landry's veto of House Bill 423 protects the rights of people like me and my daughters. People who do the responsible thing and pay for health insurance should not be penalized and recover less for their injuries. House Bill 423 would cost families like ours thousands of dollars they need to put their lives back together with. Thank you again, Governor Landry, for standing up for families like ours.
Again, I want to thank Kelly and Randy for coming here today and sharing their stories. They are here not for their own personal reasons. They're here to be a voice for the next family who may go through a similar tragedy. Their story explains how a family who suffers an injury caused by the negligence of someone else and who has paid for health insurance that covers some of their medical bills should not be penalized. This is common sense. When I start to explain those that criticize me for vetoing this bill, and then I walk them through exactly what Kelly just walked you through in real life, they say, well, I didn't know that. Because again, all we hear is from one group of people or the defense lawyers that make a living off the insurance companies that are here in this legislature. Look, let me be clear. I support reforms to our civil code that increase transparency, accountability, and accessibility to our courts. I believe we can adjust our collateral source doctrine. In fact, I offered during the session, not once, but twice, to adjust the very bill I'm vetoing in a manner that would address what the insurance company said was the most penalizing portion of the collateral source. But it went unheeded. I offered to bring the jury threshold down to 0 and offered to sign a bill that reversed the Housley presumption. I look forward to working with the legislature next year on such measures. But I also think it's important that those in the media and those that are the critics out there watch to see the number of bills that we passed today or signed by today and how it should affect the insurance premium. Because interestingly enough, hot off the press, I just got from the National Association of Insurance Commissioners a loss ratio report where the amount of premium collected in this state last year was 15.4 billion, and the amount paid out was 8.8 billion. In Mississippi, which brought us to a 57% direct loss ratio. Think about that. Hold on a second. So we talk about Mississippi. I hear, oh, the automobile insurance in Mississippi is cheaper. But yet in Mississippi, they collected $7 billion in premiums and they paid out 5.1. That's a 71% direct loss ratio. That's a higher direct loss ratio. That means that the insurance premium should be higher if we listen to what the insurance industry is saying. I would also tempt the media out there to go and look up the articles that Forbes magazine wrote on auto insurance, on the increase of auto insurance rates around the country. They wrote a very detailed article on it. They listed over a dozen things that affect auto insurance rates. None of them had to do with tort reform. Again, does that mean that we shouldn't strive to make sure that our civil code is fair and that we should not adjust it where it needs to be? Absolutely not. But I also want to point out that in 6 months as governor, I will have signed 26 tort reform measures. 26. And the media that's out there claims that I'm vetoing this bill because the trial bar showered me with excessive campaign contributions. I want to go on the record and say that 7% of the campaign contributions I received only came from the trial bar. 7%. So how does 26 tort reform bills signed by myself compare to other governors? When the 8 years that Governor Edwards was here, he signed 12. Bobby Jindal signed 39. Kathleen Blanco signed 36. Mike Foster signed 74. All of those governors, well, except for Blanco, had 8 years to reach those numbers. We have signed, I believe, more bills in the first year than any other governor out there when it comes to tort reform. So again, I look forward to working with the legislature. I appreciate the media who are here today and the people that are watching. They gave us an opportunity to clarify all of the clutter that's going on out there. Because as soon as I announced that I was going to veto this bill, I'm sure there was going to be a whole bunch of wailing and screaming and gnashing of the teeth. And so I would hope that this explanation and Kelly's story starts to give a great example of how we are committed to protecting the people of this state, not protecting special interests, protecting the people of this state. And so with that, I'm happy to answer any questions y'all may have. Yes, sir.
Governor, insurance was one of the big topics that you spoke about on the campaign trail. Most of the lawmakers that I spoke with in the last days of the session said there was some work done on insurance, but not nearly enough. I just want to get your take on why you think it is that lawmakers can't seem to get on the same page when it comes to insurance, even though the vast majority of them agree that there's an insurance crisis.
Well, because I think the insurance crisis is very complicated, right? And I think that the adjustments that we make to civil law are part and parcel. Again, I would encourage y'all to look at the Forbes, if you want to do just auto, look at Forbes's article and see all of the different things that really do affect insurance premiums. I would also say that, from a property standpoint, the amount of devastation and hurricanes that we've been subjected to certainly hurts our case here in Louisiana. However, the greater we strengthen our building codes, the way that we go through, like we put some money in the reinforced roofing project. We passed a number of bills that the Commission of Insurance said would help to open the markets to the property side. We also have a dilemma with our flood insurance that's caused by the federal government. We're in suit on that as well. So I just think there are a lot of different factors that go in to high insurance costs. We've got bad roads here in Louisiana. They're terrible. Okay, something else that we're going to work on. So I think that each and every year we should be looking at ways under which we can improve our civil law, but also we have to recognize that there are other contributing factors as well that we have to work on. In the 1990s, we had a crisis on workman's comp. We created a public-private insurance company called LWCC. In doing so, we went from having no workman's comp carriers in the state to dozens now. We may have to look at doing something of that nature when it comes to maybe the commercial auto policies as well. I don't know, but I'm committed to working to lower the premiums for our citizens.
You did address this at the end of your comments and, with everything you said here, but I did want to put the question to you directly so that you can respond directly. Is your veto of the House bill reward for trial lawyers supporting your
Kelly, come up here. This is my reason. It's not a reward for anybody but the citizens of this state. I mean, this was a public school teacher, okay, whose life was upended, who did all of the right things that we tell people you have to do. You get a job, you go to work, you get health insurance, you pay your bills, and then you end up with an injury at no fault of your own. And yet, because you do all those things, she would have gotten penalized. Now, if she wouldn't have done those responsible things, she would have been awarded. Now, how does that equate to fairness in our system? How can we support the American dream, but say that when you live up the American dream, you get penalized rather than rewarded? So this has nothing to do with the trial bar. In fact, we passed 26 tort reform measures in 6 months. What upsets me is the lack of coverage by the media on those 26 things. And say, well, we do one thing, and it's, the governor's in bed with the trial bar. Look, I'm going to tell you, I have problems with the insurance industry as much as I have problems with the trial bar. That's why that 2-year prescription extended, that limited prescription that we extended, I believe is going to have an impact. That, more than almost anything we've done, has the ability to really impact insurance rates because it's going to drive down the number of lawsuits in this state. We also have a problem with frivolous suits and people that abuse the system. We should crack down on those as well. That Housley presumption, by reversing that, I think helps us in that case as well. But I'm not going to sign a bill that I believe hurts the working class. I'm just not going to do it. All right. Is that it? Okay. Thank you.